All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When I call your name, please say present or here and raise your hand so I can mark you down as being present. Richard Balboa. Stephen Myatt. Andrea Pullings. Ms. Pullings is in the hallway. I've seen her. Tavares Dixon. Tavares Drell Dixon. Carlos Gatlin. And I might not look up, so let me hear you as well, please. Marshall Flores. Marshall Flores. Lauren Foley. Thank you, Ms. Foley. Grace Fowler. Rebecca Hunter. Jonathan Keenan. Cornelio Reyes. Cornelio Antonio Reyes. Harold Dunn. Thank you. Eric Sperling. Joshua Ibarra. Braxton Henderson. Thank you, Mr. Estrada. Heather Kossel. Cosell.
The deposition had a flight in this morning from Pacific Northwest, so she may have gotten off the traffic. I'll reach out to her.
All right, thank you, sir. Michael Lobb. Crystal Williams. Wendy Wolf. Jason Mays. Lana Calder. Tommy Jones. Tommy MacArthur Jones.
Judge, that get right. Sign explanation.
Do you know where he was extradited to? We'll need to see if he's in custody still in Louisiana. Alfonso Medina. Carmelita Chitty. Oscar Duran. Trent Gonzalez. I'm sorry, you're right, Mr. White. I apologize. Waiver of arraignment filed, approved, pretrial set July 21st. Jamie Hedden. Stephen Slayton. Mr. Abraham, I see a Stephen Slayton on Zoom. Okay, and this is something we set up Zoom. Okay. All right, I acknowledge that he is in the waiting room. Daniel Worley, waiver of arraignment. He filed, approved with pretrial set July 19th. Did you mean to set those on different dates, or do you want me to? One's on the 19th and one's on the 21st. Okay. All right. Is there anyone in the courtroom, and I've not called your name, and you believe that you're on today's docket or should be? No? Okay. Thank you. All right. Counsel, are you ready? Mr. Burns, you ready? Mr. Hawkins?
I do have a free trial intervention.
Okay, if you'll just go take your client to the clerk's office and then get you sworn, or you can ask them to come in here. Mr. Hawkins, you ready? Jason Mays. remind me, I'm still showing that Mr. Sawyer's name is attached to this case.
Judge, it is Mr. Sawyer's case. I'm standing in front today. He had a conflict. He was in the court this morning. And so ultimately, he just wanted to announce that there's, I think that the plea agreement set, they'd like a plea date set. I guess the next day to be a plea date. But Mr. Sawyer does have vacation from 6/24 to 7/4. So he's asking that the court set it sometime after that point.
All right, and I'm sorry, Ms. Grisham, for the record, this is cause number CR 2401. All right, court will set Mr. Mays to enter his plea before the court on July 7th at 9 a.m. Mr. Mays, once you sign and get the yellow copy, you're free to go, sir. We'll see you back on July 7th.
I spoke with Mr. Sawyer on this yesterday. This is going to be a time offer, so if
Mr. Mays.
he said at 1:30, so that he can still stay at 1:30.
Okay. All right. So, Mr. Mays, we're going to continue you on for July 7th, but you're going to report at 1:30 out at the Van Zandt County Jail.
Okay, so go to the jailhouse?
Yes, yes, sir. If you'll just go out there and let them know you're there for court, then they'll take you where you need to go.
Yes, sir.
Okay. So at 1:30 on July 7th.
Yes, sir.
All right. Thank you, sir. Thank you, Ms. Heisel. I appreciate that.
That's all I have here. Maybe.
Yes, thank you, Mr. Hawkins. Appreciate you being here. Mr. White, you ready?
Yes, sir.
All right. Who do you want to call first, Mr. White?
Let's call Ms. Head.
Jamie Lynn Hedden, CR 2286. All right, Ms. Head is set for pretrial.
Your Honor, we're just gonna abide by the pretrial agreement, ask court to move this over to docket call.
Okay. Okay, all right. All right, court will set Ms. Hedden for docket call. Mr. White, I have July 7th, 19th, 21st. Any of those better for you?
Let's do the 19th, Your Honor.
Okay. All right, Ms. Hedden, the court's going to set you for docket call on July 19th. That will be at 9 a.m. Ms. Hedden, once you get the yellow copy, then I need you to report over here to pretrial release. They'll have some more information for you, okay? So you can get your stuff and then you come on around, meet with Officer Machura. Who do you like next, Mr. White?
Mr. Durant.
Oscar Duran, CR 2265. Mr. Duran is set for pretrial as well.
As of right now, Your Honor, I think that there's a good chance that this may be resolved, so I'm gonna ask the court to move it over to docket call.
Okay. All right, there being no pretrial motions, contested that is, court will set Mr. Duran for docket call. Do you want that same date, July 19th?
That'll be fine, Your Honor.
All right, court sets Mr. Duran for docket call July 19th at 9 a.m. Mr. Duran, once you sign and get the yellow copy, you'll also need to report to pretrial release. Okay. You ready to go, Mr. Slate?
I am, Your Honor.
Have y'all already gone through the waiver signed? We have that in hand. Can I have that?
I knew that was gonna happen.
I want to.
Thought we already gave it to the court, but I was wrong.
I think I had, I barely.
Judge, somewhere I have seen a copy signed by Mr. White, Mr. Slate, and I believe I still need to sign off on it.
We have a problem. I could have. He's okay.
Yeah, I don't have a copy in the clerk's file or e-file, and I don't have a copy up here. So see your last one. Let me just recall that. Mr. Estrada, are you ready?
Yes, you are, Judge.
Braxton Henderson, CR 21289. All right, Mr. Henderson is set for pretrial today.
Yes, Your Honor. Two items of business that I'd like to address with the court. One, we recently filed a motion to allow transcription of a interview that was conducted at the district attorney's office. I believe that's without objection for the limited purposes of that transcription by a court reporter to be used for our expert witnesses, for them to review and render an opinion report based on that interview.
Right, I believe the court's already granted that, have I not?
I was on vacation all last week, Judge. It may have. I'm still scrolling through a week's worth of emails. I got back into town yesterday.
And while I'm looking this up, go ahead with your other issue.
The other, when Judge, we're asking for an additional pretrial, we did submit a subpoena, Justice Teacom, to Southwest Institute of Forensic Science in Dallas. The return has been filed with the court. We have been speaking with the Dallas County District Attorney's Office and with SWIFT, Your Honor. They're diligently working towards complying with the request. They are asking for some time to comply with the subpoena. They do have an anticipated date to comply by July 1st.
Any objection from the state?
No, Your Honor.
All right, and for the record, the court granted your motion for transcription on June 6th. So that should be in your e-file. If not, it's on file with the clerk.
Yes, Your Honor.
All right, the court will grant Mr. Henderson another pretrial setting in this case. And so you said post July 1st.
Yes, Your Honor.
Correct. All right, I've got the July 7th, 19th, or 21st. Any one of those better?
The 21st, Judge, that way that allow any leeway and then also to get the documents to our toxicologist.
All right, court sets Mr. Henderson for pretrial on July 21st at 9 a.m. Mr. Henderson, once you sign and get the yellow copy, you're free to go. I have it because they have it. Mr. Estrada, is there any issue on pretrial release? Mr. Waddell has indicated that either there's conversations with Mr. Henderson or you regarding some issue with Mr. Henderson and returning to the home for a reenactment or
Yes, actually,
seeing
Your Honor,
one.
today we are scheduled to meet our crash accident expert today at 10:30 and our medical examiner. They're meeting us out there at the location, but I believe the order allows for, I don't know if the Jamie co-defendants to be there, but for trial preparation purposes, I don't think there should be any issues. I think the court designated if there's any contact, it's for trial preparation purposes, that there should not be an issue.
I haven't reviewed the order. It's a concern that Mr. Waddell has. So I didn't know if y'all had been in contact with one another. I mean, no one's asked me to make a decision on anything, but he seems to be concerned about it. So perhaps y'all should speak. And if there's any issues, then if y'all want me to intervene or I need to be aware of something, then y'all need to bring it to me now rather than later.
If I can speak with Mr. Waddell, I don't think there should be an issue, Judge.
Thank you, Mr. Shaw.
Thank you.
Mr. Burns, you ready?
I am, Your Honor, do have one request. My client can't hear out of one ear, and the other two appearances when he was there.
Sure, we'll bring him up. We'll bring him up. Harold Dunn, CR 2216. Thanks, sir. Yes, we'll let you come up. Good morning, Mr. Dunn. I'm going to take just a moment and review your paperwork, okay? All right, this is cause number CR 2216, State versus Harold Wilmer Dunn Jr. And Mr. Dunn, if you will, raise your right hand, sir. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, you may put your hand down. If you can't hear me at any time, just let me know, okay? All right, Mr. Dunn, are you a United States citizen?
Yes,
Do you read, write, and speak English?
yes,
Have you ever been diagnosed with any type of mental condition?
No.
All right. In this case, you are represented by your attorney, Mr. Robert Burns. Are you pleased with his representation of you? Do
yes,
you feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
yes,
Is there anything about this paperwork that you've read and signed today with Mr. Burns that you do not understand?
no,
Do you understand that by entering into a pretrial intervention contract, there are a few very important rights that you would be giving up and waiving today? Do you understand that?
yes,
Do you understand if the court approves this, you would be waiving your right to a jury trial in this case?
yes,
You understand that you would be waiving your right to have certain criminal records expunged if you successfully complete this case and the case is dismissed? You understand that?
yes,
And you've discussed these things with Mr. Burns.
yes,
You also understand that you would also be agreeing to the admissibility of certain evidence should you violate the pretrial intervention contract, be brought back to court, and be taken to a trial before the court. That certain evidence you would already be agreeing that it is admissible into evidence. You understand that?
yes,
That would be things such as the offense report and other reports from law enforcement that might not otherwise be admissible in a trial. You understand that?
yes,
And you've taken enough time to consider the consequences of your decisions today,
yes,
and you still wish to go forward.
yes, sir.
All right. And I see here that the agreement is that Mr. Dunn would go on to the pretrial intervention contract for a period of 2 years on the charge of aggravated assault with a deadly weapon. And Mr. Dunn, it's important for you to understand that the range of punishment for aggravated assault with a deadly weapon, which is a second-degree felony, if convicted and sentenced, would be punishment from a minimum 2 years to a maximum 20 years in prison, and an optional fine not to exceed $10,000. Do you understand that range of punishment?
Yes.
All right, and Mr. Burns, you've explained your client's legal rights to him, and you explained this pretrial intervention contract.
I did, Your Honor.
And do you believe that he understands all of the terms and the conditions and the law as it applies to him in this case?
Yes, and just for the record, we went over it in my office. We read it together thoroughly. He took the document home and thought about it for a few days, and then over phone consultation agreed that he wanted to enter into this agreement.
Okay.
So he had plenty of time to think about it.
All right. All right. So, Mr. Dunn, at this time, I would ask you, how do you plead to the charge of aggravated assault with a deadly weapon?
Guilty.
And are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
All right. The court will accept the defendant's plea of guilt. The court will approve the placement of Mr. Dunn on the pretrial intervention contract at this time under the terms and conditions of the contract.
Judge, if I may, also Mr. Burns has informed me that he has mailed us the pretrial intervention fee. We're accepting that as payment. We will watch for that in the coming days. If not, we will notify him and make sure that payment is made promptly at that time.
All right, thank you, Mr. Roy. All right, Mr. Dunn. I'm also going to find that you have intentionally, knowingly, and voluntarily waived your right to a jury trial in this case, and that you have been advised by counsel, admonished by the court, and the state's agreed to waive their right to a jury trial in this case as well.
Yes.
Right, Mr. Dunn, the court has approved your placement on the pretrial intervention contract program. So at this time, I'm going to have you visit with Officer Ventura here, and she'll give you more information about the program. Okay?
Okay.
All right.
Thank you.
You're welcome.
Thank you, Your Honor.
Thank you, Ms. Burns. Mr. Stevens, are you ready?
Yes.
Lana Calder. This is cause numbers CR 22-3, CR 21-322, State versus Lana Michelle Calder. Go ahead, Mr. Stevens. Except for a docket call.
We're set for docket call. We're gonna ask for another docket call. Prosecutor and I are real close to working something out. I think with another docket call, we'll be able to work that out without it going to the trial docket office. So I think that's not being,
States are close. The newer cases is up first docket, so Mr. Stevens and I are in discussions.
Okay, all right. Based on the agreement, the court will give Ms. Calder another docket call. I've got July 7th, 19th, and 21st.
I'm here on the 19th, Judge, so that worked great. If that
All right, Ms. Calder, the court sets you for July 19th. That will be at 9 a.m. for docket call. After you sign and get the yellow copy, I need you to report to the pretrial release officer, okay, before you leave. Just a moment, I'll try to get her and the baby out of here. Alfonso Medina, CR 22-112. Mr. Medina set for pretrial.
Yes, sir, Judge. And I was just notified Friday that the videos are ready to be picked up. I haven't picked them up yet. I'm gonna pick them up today. But so we're going to answer the pre-trial.
All right, court will set Mr. Medina for additional pretrial on July 19th at 9 a.m. Mr. Medina, once you sign and get the yellow copy, you're free to go. Check on Tommy Jones.
Judge, I just heard on Mr. Jones, Tommy Jones, that he was released to his mom.
Check when was it?
I didn't know. He stepped away.
Okay. Anything else on that? All right. Thank you, Mr. Stevens. That's what Ms. Taberham was also telling me. All right. CR 22-106-107, Say versus Tommy MacArthur Jones. Mr. Jones was set for pre-trial today. Our records indicate that he was released from Bossier Parish, Louisiana on May 16th. Is that correct?
Correct. That's the information I got, Judge.
Okay.
I'm going to try to track him down, but again, like I say, I haven't heard from him.
Okay. All right. Court will double check its notice, and if Mr. Jones has had proper notice, the court will issue a judgment nisi and alias capias. Is that all you have today?
Yes, sir.
All right.
I can see you this afternoon.
Sure. Yes, sir. Mr. Slayton, you got to take your hat off. All right. Also need you to unmute your phone.
Okay. Can you hear me now?
Yes, sir. I can hear you. Can you hear me?
Yes, sir.
All right. Can you see Mr. White also?
No, sir. Where's he?
You may have to move left or right if you want to see Mr. White. Maybe you have to swipe left or right.
Okay. All right, I got y'all. All right, good.
All right. This is cause number CR 2194, State of Texas versus Stephen Kyle Slayton. Mr. White, it's my understanding that your client wants to waive his right to a jury trial and enter a plea in this case. Is that correct?
That's correct, Your Honor. Note for the record that I have explained to Mr. Slayton the consequences of waiving this right, that there's no way he gets it back once it's waived. I believe that he's executed that waiver knowingly, intelligently, and voluntarily.
Thank you, Mr. White. Mr. Slayton, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may place your hand down. Your name is Stephen Kyle Slayton, is that correct?
Yes, sir.
And Mr. Slayton, you understand that if you waive your right to a jury trial, well, first of all, do you understand that you have the absolute right to a jury trial? You understand that?
Yes, sir.
Understand the Constitution and the laws of the state guarantee that you have the right to take your case in front of a jury and let them decide whether or not the state has met its burden beyond a reasonable doubt of your guilt. You understand that?
Yes, sir.
You understand that by waiving your right to a jury trial, you're waiving your right to confront the state's witnesses and cross-examine their evidence in front of that jury.
Yes, sir.
You understand that once you waive your right to a jury trial, it won't be restored to you, meaning you can't change your mind here in a couple of weeks and say, Judge, I've changed my mind. Now I want a jury trial. You could still have a trial, It just will not be before a jury of your peers. It would be before the court. Do you understand that?
Yes, sir.
Mr. Slayton, you've talked with Mr. White about this. Is that correct?
Yes.
Is there anything about this document that you signed that's called waiver of jury trial that you do not understand?
No, sir.
And is that your signature here on this document?
Yes, sir.
All right. And have you made this decision of your own free will in the court? Meaning, has anybody threatened, forced, or pressured you to waive your right to a jury trial?
No, sir.
Okay. All right. The court's going to find that Mr. Slayton has been admonished as to his right to a jury trial, that he's intentionally, knowingly, and voluntarily waived that right, that he has been joined by counsel, Mr. White, and the state is also joined in waiving their right to a jury trial as well. The court hereby approves the waiver of jury trial of Stephen Kyle Slayton, and the court will set Mr. Slayton to resolve his case by plea agreement. Mr. White, do you have a requested date? You want that July 19th date?
I will be here also for the 21st.
21st? Yes, sir. All right, Mr. Slayton, the court's going to order you back before the court to enter your plea on July 21st. That will be, is that a probation plea or a time plea, Mr.
It's
White?
going to be a probation.
All right, so that will be at 9 a.m., Mr. Slayton. All right, July 21st at 9 a.m., and this will be the only notice that you get.
Yes, sir. Thank you.
All right, quickly, Your Honor, Mr. Slayton, my paralegal Nikki will be messaging you through our office system with this date, okay? So look at your
Okay.
phone. We're not gonna send you a hard copy. We're just gonna,
I'll keep in touch.
okay?
All right. Thank you, sir.
All right, thank you, Mr. Slayton. You're free to go. I'm about to call her. Get her out of here. I think Rachel said that she put the baby on her knee or something. Sit her over there, bounce her up and down. I'll call her. As soon as she comes in, I'll call her. That way you're not out there. All right, court calls cause number CR 21-140 State versus Andrea Pullings for a sanctioned sport status hearing. All right, Ms. Pullings, got an update from the probation department. The last time we were in court, I told you certain things that you needed to do in order to comply with your community service. You were to pay your probation office $115 to get caught up. You were to pay the court collection officer or the clerk $160 in order to get you caught up on your probation. and you were ordered to do your mental health evaluation, and you were ordered to do 12 hours of community service. My report says that you didn't do any of those things. Is that right?
It's correct, but like when I told her the place I was supposed to go do my community service, they was making me pay, and I just left the job, and I just got daycare yesterday.
So what kind of job do you have now?
I'm nervous. I'm on phone,
And are you a full-time employee?
part-time,
How many hours are you gonna be working?
30.
30? And you started that yesterday? Why did you not do your mental health evaluation?
I did there is about because of COVID. So they told me I have to wait until Thursday. They gave me a counselor. I go see her every other Wednesday.
So when are you gonna do it?
Like when I'm bored.
When are you gonna do the evaluation? Thursday?
The only thing they did for me was prescribe me medication, depression medication.
Say that again.
The only thing she did was prescribe me depression medication.
Ms. Pullings. Really at the end of the line. I don't know what else to do with you. I understand that you just got the job, I understand that you got all your kids, but you got these obligations that you have to comply with in order to be on probation. We can't let people just not do their probation.
Financial help with nobody. Like I'm by myself with my 2 kids. And I just got my daycare started. It don't work like that. You have to wait until they approve.
It looks like at this rate, you were supposed to get off probation October of next year. Every month, you're just falling further and further behind. And so one of 2 things is going to happen. You're either going to have to get extended and be on probation even longer in order to get caught back up, which is going to cost you more money every month, more community service, more time, or you're going to get revoked. And you're going to get a prison sentence or a jail sentence. And you're looking at, it says state jail felony. So that's 6 months to 2 years. That's day for day. That's no parole prison. No parole prison. So I'm going to give you one more opportunity. It's the same thing that I give everyone else that's in your position. And you can take it or leave it. It's your choice today. I'm not going to make you take it. You're going to tell me whether you want to do it or not. Okay. And this would be the last thing that I can do for you. After this, I think the probation department is going to file a report with the DA's office. The next thing will be a motion to adjudicate, warrant. The next time you come in here, you'll be in a jumpsuit and you'll be in the jail. Somebody else will be watching your kids, whether it's a family member, a loved one, or the Department of Family and Protective Services, because there's no one to take care of. So I really want you to think about that. Today is the 14th. I'm going to set you on August 9th. I'm going to reset you to August 9th. I'm going to give you the rest of this month and all of July. And you've got to complete your mental health evaluation. You have to pay $115 to probation. You have to pay $160 to the court for your court costs and fees. And you have to do 12 hours of community service. I'm not going to hold June against you. I want all that done in July. You're going to be behind. When we come back in August, I want the probation department to tell me that you did all these things. You already owed me all of these things. You already owed me that. Now I'm gonna give you that same opportunity in July. But here's the catch. For everything that you don't do, it's gonna cost you a day in jail. That means if you do 2 out of 4, how many days of jail you're gonna do? If you do 2 things out of 4 things, how many days of jail are you gonna do? Spoilings. Are you with me? Spoilings. Spoilings. Are you with me? Pull yourself together. All right, listen. Pull yourself together. Talk with me for a second, okay? We'll try harder. Try harder. You can do it. All right, listen. I'm giving you 4 things. I'm giving you 4 things to do. Two of them are money. One of them is community service, and one is just go and do your mental health evaluation. And I'm saying for everything that you don't do will be a day in jail. Remember, I told you at the beginning, you get to decide whether you want to do this or not. You can tell me no. All right, this is your option. So if you come back in July and you've paid the money, but you haven't done your community service and you haven't done your mental health evaluation, then how many days of jail are you going to do? You're going to do 2. For everything that you don't do is a day in jail. That's so we can try to keep you on probation. If you don't want to do that, tell me you don't want to do that. In probation department, they can decide if they want to file a motion and in this probation case.
She really don't care about it. I be telling her to help me, she don't help me. I don't even go and report. We talk on the phone every month. She asks me questions and that's it. She's really not reporting the truth.
Well, do you want to report down here to my probation officers?
Yes.
Okay, do you want me to transfer you back and you come back and report here
I don't
and do your community service here?
Different probation officer.
I can't tell where are you at. Are you in Dallas County? I can't tell Dallas County who your probation officer is going to be. If you want to come back here to Van Zandt County, then my probation department and their officers will meet with you. They'll work with you. They'll tell you. They'll help you with probation. You're in a situation as Pullings, and you're going to have to figure out how to get out of it. There's really only 2 ways. Either you're going to be on probation and do what you got to do to get through with it, or you're going to end up getting revoked and going to prison. So do you want to do this deal? What we call it is we call it a buyback. Call it a buyback. I give you those 4 things to do. You go and do those. You don't go to jail. For every one thing that you don't do is a day that you go to jail. And I'll tell you when you're going to jail. I won't make you go to jail when you come to court. We'll pick out the days today, and you can do it on the weekend, and you can arrange for childcare for your kids, and you can come down and you can serve 1 day up to 4 days in jail for everything that you don't do. And then we'll leave you on probation, and we'll keep on doing this song and dance until we get you current and you get off of probation.
She said I was only delinquent $177.
I'm sorry, I can't hear you. Speak in that microphone.
She said I was only delinquent $177.
That can't be. That can't be. I've got you delinquent $520. I've got you having worked 0 community service. I mean, you're behind. The whole purpose of us being here today, Ms. Bullings, is trying to figure out how can we get you back online with your probation so that you can expire in October of 23. This, and what we've told you is you have to pay $160 a month on your court costs. You have to pay $115 to your probation officers to get caught back up because you've been behind. You're not delinquent $177. You're delinquent that just from last month on just your court costs alone. So what we're trying to do is get your attention and say, avoid prison, Ms. Bullings, do these things, stay on probation, or this is going to happen. This is what we're trying to do.
I understand.
So if you understand, then what do you want to do? Do you want to have this opportunity to make those payments, to do your community service, to do your mental health evaluation? I'm not going to hold June against you. You just got a job. That's progress. That's what we need. I'm not going to hold that against you. You're still going to be behind, but I'll give you July. If you can get all 4 of those things done in July, when you come back in August, we'll talk about it and we'll set a new goal and we'll keep on meeting those goals or trying to. Do you want to do that? All right. All right. So I'm ordering you to pay $115 $115 to your probation department before August 9th, to pay $160 to the court, the clerk's office before August 9th, to do 12 hours of community service before August 9th. That's almost 2 months. Everyone else is doing that in 1 month. I'm giving you almost 2 months to do that. And you got to have your mental health evaluation done before August 9th.
I mean, I can do it about that. She said I just have to wait in line.
Well, go handle your business. Whatever she says, whatever you got to do. When you leave here, it's on you. You handle your business. It's not my job to go call your officer to make sure that you're getting the information or that she's getting it to you. That's your job. Okay? For every one of those that you don't do, I'm going to order you to do a day in jail. All right? So I'm going to sign that order today. So I want you to come back here and meet with Ms. Burns. We're gonna pick out. Okay, come back here and see Ms. Burns, and we're gonna have you sign this notice. We're gonna give that to you. It's gonna have your reset date of August 9th at 9 a.m. Okay, so come on through here and meet with Ms. Burns.
What was the 15?
Probation.
Probation.
Probation. 160 to work. 12 hours of service. Yes, sir. Mr. White, Mr. Adams, either one of you ready? If not, Mr. Main's ready to go. Ready? Are you ready on, Mr. Adams? Is Mr. Dixon here? Tavares Dixon? He's not here. Tavares Drell Dixon? He wasn't here when I called his name at 9. He's not here now. Carlos Gatlin, CR 21288. Mr. Gatlin is set for docket call.
Yes, Your Honor. I'm going to request the court set us for another docket call. There is an issue about video footage that I do not have. There's a screenshot or a photograph of Mr. Gatlin's vehicle that would appear, from what I see, to contradict the stated probable cause for the traffic stop that led to Mr. Gatlin's arrest. I would assume that photograph is a still taken from dash cam footage from the patrolman's car or from the officer's car. The case inventory sheet that I have, I think indicates the existence of dash cam footage. We've got a 3914 request on file, have for a while. And I would like the DA's office to make to find out if where that video is and get it to me so I can compare the contents of the video with what I see in the photograph.
So what I'm hearing you say is that in your discovery, you have a photograph. That photograph appears to come from some kind of body cam or dash cam, but you don't have a body cam or dash cam evidence.
That is correct, Ron. And if this will determine whether or not I file a motion to suppress.
State.
Judge, I was unaware. I state would be unopposed to his request for recess, and we can try to figure out if it exists, and if it does, then we can get it for Mr. Adams.
All right. Court will reset Mr. Gatlin for additional docket call. Mr. Adams, I've got July 7th, 19th, 21st. Seventh.
Yes.
All right, court sets Mr. Gatlin for July 7th. That'd be at 9 a.m. Mr. Gatlin, once you sign and get the yellow copy, you're free to go. All right, with Mr. Dixon not being here, is that all you have this morning?
It is, Your Honor. That's what, Your Honor.
Carmelita Chitty, CR 2291 and 92. This Chitty is set for pretrial today.
That's correct, Your Honor. I have filed the three normal motions that I normally do on 2292 and in 2291. I filed a motion to adopt since the two cases are virtually the same. Talked with the state. They have no problem with us resetting this for a second pretrial. And I think there's a strong chance we'll get this resolved.
What's the reason for the additional pretrial?
I'm not prepared as much as
Okay. Any objection from the state? Okay. All right, court will reset Ms. Chitty for an additional pretrial, give Mr. White time to work on the case. I've got July 7th, 19th, and 21st, Mr. White. 19th. All right, Ms. Chitty, you're ordered back before the court for pretrial on July 19th. That will be at 9 a.m. Once you sign to get the yellow copy, I need you to report to pretrial release. Oh, never mind. She says she's already taken care of that, so you'll be free to go.
That's all I have.
Yes, thank you, Mr. White. Who would you like called first, sir?
Just recall this Coastal, application for recording of our case.
Heather Kosel, CR 2230. Turn your cell phones off. All right, Ms. Kosel, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may place your hand down. Ms. Kosel, your name is Heather Irene Kosel, is that correct?
Yes.
Am I saying your last name correctly?
Yes.
All right. And Ms. Kosel, are you a United States citizen?
Yes.
Do you read, write, and speak English?
I do.
And have you ever been diagnosed with any type of mental condition?
No. Retardedness sometimes.
You say,
Retardedness sometimes.
and in this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes.
You feel like you've had enough time to talk with him about your case and you understand the consequences of your plea today?
Yes.
Are you pleased with his representation of you?
I am.
Mr. Manning, do you believe your client to be competent today?
She is.
And you've explained to her her legal rights?
I have.
And you believe that she understands those and the consequences of her plea today?
She does.
All right, Ms. Kosel, you are charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 1 in an amount of greater than or equal to 1 gram but less than 4 grams.
Judge, we are abandoning the second paragraph. They were concurrence from another state. It's not overly clear as to what they were.
Okay, thank you. That typically is a third-degree felony offense, Ms. Kosel, but the state has alleged that you have a prior conviction, which, if found to be true, would elevate your range of punishment to that of a second-degree felony offense, which would have a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine not more than $10,000. Do you understand that full range of punishment? And I see here that the plea agreement is that you would plead guilty to that charge and you would plead true to the enhancement paragraph contained in the first paragraph. And in exchange for your pleas of guilt and plea of true, that the state would recommend that your punishment be assessed today at 5 years confinement in prison, but that sentence would be suspended and you'd be placed on probation or community supervision for 5 years. You'd be ordered to pay a $2,500 fine plus restitution, court costs, and reimbursement fees. Is that your understanding of the plea agreement?
Yes.
All right, Ms. Kosel, understanding the plea agreement, understanding the range of punishment, how do you plead to that charge? Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason? Has anyone threatened or forced or pressured you to plead guilty today? As to the enhancement paragraph, alleging that you were convicted on June 18th of 2013 in Churchill County, Nevada, for the offense of embezzlement, value of $3,500 or more, a category B felony. Is that allegation true or not true?
Yes, it is.
All right, court accepts the defendant's plea of guilt and the defendant's plea of true. Mr. Manning, any objection to state's evidence?
No objection to state's evidence.
State's evidence is admitted and the court does take judicial notice of the defendant's judicial confession and plea of truth. Anything further from the state?
Yes, Your Honor, briefly, Ms. Kosel is transferring her probation, I believe, to court.
That's correct.
And she's already done, through her and her attorney have already gone through the probation department, saying she's already given them all the legwork, state has no objection to transferring her to that administration.
Any further from defense?
Judge, that is correct. Reached out to the interstate compact officer, Mr. Gann, provided him with documentation as well as a license. We have a license to present to him today or to the probation department to speed along that process of getting her transferred to where she resides.
All right, court has reviewed the evidence. I do find enough evidence to convict Ms. Kosel of this offense. Court will follow the plea agreement in this case. The court hereby convicts Heather Irene Kosel of possession of a controlled substance in penalty group 1 gram to 4 grams. Court finds the enhancement paragraph allegation to be true. The court will sentence Ms. Kosel pursuant to the plea agreement and the elevated range of punishment to 5 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will suspend that sentence, place her on 5 years community supervision, order her to pay a $2,500 fine, $180 restitution, $290 court cost, and $535 reimbursement fees. Court finds that the state has agreed to abandon enhancement paragraph 2. All right, Ms. Kosel, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward here to be fingerprinted by Deputy Phillips. After that, I want you to report to the probation officers over here through this door. Who would you like next, Mr. Manning?
Judge, we can call Ms. Williams.
Crystal Williams, CR 2252. All right, Ms. Williams is set for free trial today.
Yes, Judge. At this time, we have reached an agreement and request that she be set for a plea.
All right, I have July 7th. Well, maybe you're on the fifth, is that correct? I also have the fifth, if you need it, fifth, seventh, 19th,
I
21st.
believe in July, I'm in trial on the seventh, double check. Yes, Judge, I'm in trial on the seventh, so if I could set those on the fifth.
Okay. All right, court will set Ms. Williams then to enter a plea on July 5th. That will be at 9 a.m., Ms. Williams. Once you sign, you get the yellow copy, you're free to go. Wendy Wolf.
Yes.
Wendy Wolf, CR 2253. Ms. Wolf is set for pretrial.
Yes, Judge, we've also reached an agreement in her case. I'm gonna request to be reset on July fifth for a plea.
All right, court will enter July 5th for the plea, and that will be at 9 a.m. Ms. Wolf, once you sign and get the yellow copy, you're free to go. We'll see you back on July 5th. Just one second, Mr. Manning. We'll call Mr. Law. He's your only other one, correct?
That's correct, Judge.
Michael Lobb, CR 2269. All right, Mr. Lobb is set for pretrial today.
Yes, Judge, we have no contested pretrial matters, and we request that he be set for docket call.
All right, you want him set on that July 5th, or we've also got the other dates, 5, 5, 7, 19, or 20. Well, you said 7's out, so.
If we can set it a little bit later, I have some additional discovery to go over with Mr. Lobb. You said 19 or what?
Or 21st.
If we can do the 21st, Judge.
All right, Mr. Lobb, court's going to set you for you want an additional pretrial, Mr. Manning, is that what you said? It's set for pretrial today.
Judge, we're ready to proceed to docket call. I just want to go over some stuff with that night.
Okay. All right, court will set Mr. Lobb then for docket call on July 21st. That will be at 9 a.m.
Matt. Oh, yeah. From that one. Just
All right, Mr. Law, there's a warrant for your arrest for your failure to appear in this court on June 2nd.
And Judge, we had requested a reset. Per Ms. Abraham, after June 2nd, Mr. Law contacted me about his situation. His travel arrangements had fallen through and he was not able to make it from where he was in the county by foot. He was able to make it later and make a phone call to me. And that's why we requested today's date is to be reset.
Okay. Go ahead and have a seat over here. I'm gonna have you drug tested. All right, you pass, you go home. You fail, you stay with me.
All right.
Have a seat over here.
Judge, I believe that concludes my business. May I be excused?
Yes.
Pending Mr. Law.
Morning, you ready?
Ready, if you've got a moment, Your Honor.
Let's do it. Who are you gonna call first?
Judge, I'm going to call Miss Rebecca Hunter.
Rebecca Hunter,
Judge, we're
CR
asking.
21387. Miss Hunter set for docket call. Go ahead.
Sorry about that, Judge. Yes, we're asking the court for another docket call. I visited with the state. They're not opposed to it. Ms. Hunter may have another charge pending, which is not yet indicted, and we're asking for some time to see if we can resolve all these issues together. So
Is that it? Is that in this county?
it's a Van Zandt, it'll be a Van Zandt case. Yes, Judge.
Any objection from the state?
That's our understanding.
All right. What date do you want? 7/19/21 of July.
Looks good.
Okay. All right, we're gonna set Ms. Hunter then for docket call on July 19th. That will be at 9 a.m. Ms. Hunter, I showed that there's two issues with your pretrial release. One, it says that you didn't report in May.
Yes, sir.
You didn't report in May.
I never
Pretrial
was given a time or place to report, sir.
Okay, and it says you're $215 delinquent.
I brought another $100 payment today.
How much?
Another $100 payment today.
It says you're $200 delinquent though.
I understand. I just started working the last time I appeared in court, sir. So
All right, I want you to get your yellow copy and then come over here and have a seat. Let me work through these issues. I didn't look at the fix up to see it. Are you ready, Jonathan?
Any of them. Ms. Fowler, who's next?
Ms. Fowler, come on up. Grace Ann Fowler, CR 2333334. I believe that this is just the status on Ms. Fowler and her outpatient restoration.
It is, Judge, and she's doing very well. She's approaching the part of her treatment where she's going to go into maintenance, which will mean that the treatments will be just weekly check-ins instead of the intense check-ins she's been doing. As you can see, she's doing incredibly better. She's here without Chrissy, her daughter, and caretaker and guardian, and without her husband, which is the first time I've ever seen her be able to function outside of that family unit. So I'm hoping that she'll continue to improve and that we're asking the court for a reset to allow that maintenance to go forward. And then we're almost in a position to revisit the state with what resolution may be reached in this matter.
Any update for the court on anything that you can disclose about her treatment and how she's doing? Any progress?
She's made significant progress. She's on track to complete this month. She's voluntarily agreed to stay in a maintenance program with us. Like that, it's beneficial for her personally, not just with the restoration. So I feel like significant progress.
she's brought me a long way.
It's good. So
I'm
Ms.
not there yet. She's brought me a long way.
So I'm assuming that she's making all of her appointments, she's being cooperative, doing everything that you need her to do to successfully participate in the program. Okay, glad to hear that, Ms. Fowler. I'm glad to hear it. You do look a lot better today, and a lot different
I
than
feel
we've seen you in the past.
I feel a lot better.
All right, about how much of a reset do you want, Mr. Ashmore? How much time do you think we need before we get another update on Ms. Fowler?
I mean, if the court's willing to go further than a month, I'd request that. Again, I'll do whatever's in the court's comfort level. Yeah, I know the 4th of February is not a reasonable request, but something in August might be smart, just to, more than 4 weeks, less than 8, somewhere in that 5-6 week window.
And you concur? Okay, so 4 to 6 weeks. Stay.
Stacy.
What about August 23rd? If that's not available, I have a couple earlier than that, August 9th and 11th.
August 23rd looks,
23rd?
that's open. Thank you, Judge.
All right, Ms. Fowler, we're gonna bring you back for another status. Hope to continue still getting the positive news. That'll be August 23rd at 9 a.m. Okay?
Thank you. Thank you for everybody being patient with me. I
You're
really
welcome.
appreciate it.
Lauren Foley, CR 21-262. All right, Ms. Foley is set for docket call today.
Judge, the state and I are unfortunately not able to reach an agreement. We're gonna have to ask for a jury trial setting. I mean, Ms. Foley has no criminal history. We understand that this is not an insignificant offense. She's not a drug user. And if the offer is a conviction with prison time, when I have represented women who've been a danger and reckless to their children and have gotten deferred offers even. Ms. Foley sees that disparity and she's asking for a jury trial. I do ask the court for leave to file one last pretrial motion when the time is right for an expert regarding her mental health. If the court would allow us leave to do that, I was hoping to be able to avoid that. But I think there's going to be mental health issues, including postpartum, that are going to require some expert testimony if we're going to try this case.
Court will grant you leave to file pretrial motion late. And what is the offer from the state so we can have it on the record?
I believe not in the last almost 15 months.
15 months.
This is a state jail offense.
All right, the court will find that Ms. Foley has rejected the offer of 15 months from the state. The court will set her for jury selection. We'll begin the jury selection process on we'll begin that on August 1st. I believe that's the next jury trial setting that I have, August 1st. So Ms. Foley, on August 1st, when you report to the courthouse, you will not be coming to the court to the courtroom. You'll report to the second floor and my staff will be out there and they'll assist you with paperwork. Your case will not go to trial on the 1st, because you'll need to check in and they'll give you a new date. Okay?
Yes.
Turn your phones off. I know that you're told over and over to turn your phones off before you come in here. Very disruptive. Either turn it off. If you don't know how to turn it off, give it to the bailiff. Jonathan Keenan. All right, Mr. Keenan is set for pretrial CR 2229.
Same, he's requesting a jury trial, Your Honor, rejecting the state's offer.
All right, what is the offer that's been rejected?
Working on lots of windows.
I think I have it. It's 10 TDC, Your Honor. Or at least that's my last email from Ms. Heisel in April.
That's correct.
That's correct. All right, and so does your client understand that rejecting 10 years today means that the court will not entertain a plea agreement later unless it's brought to the attention of the court well before trial?
I think it'd probably be something I've explained to him, but I wouldn't oppose the court admonishing him here on the record about that. You understand that, Mr. Keenan? He's not gonna allow us to enter a plea with the state.
No plea agreement.
No plea agreement. Okay. All right, so if you change your mind at a later date, I'm gonna tell you no.
If it's put down to a misdemeanor, I will not take the plea agreement.
Okay. All right, court will place Mr. Keenan on the jury selection docket beginning August 1st. Same thing that I told the young lady before you. You'll report down at the second floor of this courthouse, and my staff will be down there. They'll have a reset paperwork for you. They'll give you your next date. They'll continue to do that until your case is called for trial.
Thank you, sir.
And Mr. Keenan, once you sign and get the yellow copy, then I need you to report over here to pretrial release. We're going to conduct a UA today. Is Cornelio Reyes here? You are? All right, come on up, Mr. Reyes. Mr. Reyes, I called your case at 9 o'clock and you were not here.
Yeah, I got a little lost. I got turned around in Wills Point, looking for. It said Commerce Street, right? But I had to go down 80 to get over here. I don't have a cell phone, so I couldn't use GPS.
Okay. Let's take your word for it. All right, Mr. Reyes is set for pretrial. This is CR 22-114. Go ahead, Mr. Ashton.
Judge, we have a TDCJ offer, not really because of this offense, but because Mr. Reyes unfortunately made some mistakes as a very young man. We're asking for a short reset, another docket call. He has not had a chance to look at the video, even though we have it, we've got it, we've extracted it, we've viewed it. And I'm going to work with him this morning so he can see it. But we're just asking for a short reset so we can come back at the state, see if we can reach an agreement and plead this out. Mr. Reyes also did call me yesterday, and he's having some struggle with the fuel prices, this, that, and the other, and he said that he might have some difficulty getting here. I saw him here, so I didn't know that he was not on time at the 9 a.m. phone call. But I know he's endeavored to come because he actually gave our office the heads up that this would be a problem last week.
All right, court will set Mr. Reyes for docket call. What date do you want? Mr.
19, I think, works since we're here on this, on this Hunter. That's all right with the court.
All right, court sets Mr. Reyes for docket call on July 19th. Mr. Reyes, once you sign and get the yellow copy, you're free to go.
Oh, sorry, Judge, we need to clarify for the record. I guess we had We warned the state down to 6 years TDC. That's the proposed offer. It's not yet agreed on. See. May he be excused.
Yes, he's free to go.
And then Mr. Flores is last.
All right, Mr. Flores, you can just come right up here to the side. It's fine. This will be cause numbers CR 21-165 and CR 22-18, State versus Marshall Flores, set for docket call in each case.
Judge, we understand the state's offer is 12 on all our business here in Van Zandt County. Unfortunately, Mr. Flores is not in agreement with that, so we're asking the court to set this for jury selection, please.
All right, court will set Mr. Flores then for jury selection beginning August 1st. That will be at 8:30. Mr. Flores, you'll report down to the second floor. Actually, yeah, go to the second floor. You'll go in through I'm assuming you're coming in through the tunnel and riding the elevator. You'll stop on the second floor and my staff will be there and they'll assist you with the paperwork, okay? That'll be on August 1st.
That's it for me, Your Honor, until this afternoon. May I be excused?
Oh, let me see.
You gotta help him get that stuff
Double
back to
check,
eBay, Judge.
double check. Yes, sir. I got you checked off.
Okay, thanks.
Do you have anything else?
Judge, I saw Mr. Dixon in the hall, but Mr. Waddell got a hold of him before I could.
Okay.
Sent him over to the bank to get a money order, so. I'm cussing Mr. Waddell right now.
Oh, Mr. Waddell did a good job then.
Money.
Okay. All right. Richard Balboa. All right, this is cause number CR 22-124. Mr. Balboa, it appears that you've been charged with evading arrest or detention with a vehicle. That's a third-degree felony offense. If convicted and sentenced, it carries a range of punishment of not less than 2 years or more than 20 years confinement in prison and a fine not more than $10,000. I see that you've applied for a court-appointed attorney. Fortunately for you, you do not meet the indigency requirements under the law, so the court is not going to appoint you an attorney today. What I can do is I can reset your case for about 30 days, give you an opportunity to go hire an attorney and bring them back with you. Okay? If I reset you for about 30 days, do you believe you can accomplish that? Oh, I'm sorry. I'm sorry. Thank you. So range of punishment is not less than 2 years or more than 10 years confinement in prison, and the fine is the same, not more than $10,000. All right, court's going to reset you, Mr. Balboa, for arraignment and status to hire an attorney. Today's the 14th. I'm going to bring you back on Tuesday, July 19th. All right, so it gives you more than 30 days. Mr. Balboa, where are you from? Where do you live? You live in Thailand? Okay. I was going to give you a tip that whenever you're speaking with attorneys, make sure they know that the case is here. Some attorneys come to this county, some don't. If you don't have luck in Tyler, then obviously, speaking with an attorney in this area would be beneficial. Okay. But there's plenty in Tyler that do come over here. So, Odie, I usually just write on there to hire attorney. There may be another down dates on the left. I just said to hire attorney. And let me mark on there the charge, the range. So take this. Stephen Myatt, CR 22-154. Mr. Myatt charged by indictment with possession of a controlled substance, penalty group 1 or 1B, greater than or equal to 1 gram, less than 4 grams. Also a third-degree felony offense, which does carry a range of punishment of not less than 2 years or more than 10 years confinement in prison and a fine not more than $10,000. Mr. Myatt, you've also requested a court-appointed attorney. The court finds that you do not meet the financial requirements for court-appointed counsel. I can extend to you the same offer that I extended to Mr. Balboa. I can reset you for about 30 days, allow you to go hire an attorney to come back and represent you on the charge, or you can choose to represent yourself. And if that's the case, then we'll have to talk about what that means and go through your qualifications and things of that nature.
Yeah, I don't want to represent myself.
That's a wise choice. All right, so if I reset you to July 19th, you believe that they'll give you enough time to consult an attorney and hire one?
Yes, sir.
All right. Court will set you for arraignment on July 19th and status to hire an attorney. That will also be at 9 a.m. Okay. And so, Mr. Myatt, once Deputy Phillips brings you this notice of appearance, you're going to sign that. We're going to give you the yellow copy. And then I need you to report to the pretrial release officers. They're going to have paperwork for you, which is your conditions of pretrial release, which means these are conditions that you have to comply with in order to stay on bail in this case. And you're going to see what they are. It's going to be no alcohol, no drugs, no new offenses, things of that nature.
Yes.
Okay. Yeah, you come on up. Mr. Dixon. CR 21-211, State versus Tavares Drill Dixon, set for docket call. Go ahead, Mr. Adams.
Thank you, Your Honor. And for the record, Mr. Dixon was late this morning. However, point out to the court that he travels from Alexandria, Louisiana, and he's been here religiously. He's here today. I'm pleased to announce to the court that the state and I have reached a plea agreement, or the state and Mr. Dixon have reached a plea agreement, the terms of which would be a guilty plea to a lesser included offense of possession of marijuana. And the consequence would be time served in the Van Zandt County Jail. We don't have the paperwork prepared for that today. So I would ask the court to set us for a plea hearing, considering the fact that it is a plea for time that has already been served. I wouldn't want to assume the court's acquiescence to the terms of our plea agreement. However, in light of Mr. Dixon's residing in Alexandria, if we could ask the court's indulgence to allow him to attend the plea hearing by Zoom, would be very much appreciated. I've told Mr. Dixon we're not entitled to that, but we could at least request that.
Where are we at on your pretrial release money? Where are we at on that? You made a payment today?
Money over today.
How much is that? $50. I show that you're delinquent 440.
I need to get $440.
Well, this is what it's going to come down to. So you're wanting to enter the plea. All right. You're wanting to come back and enter a plea, or actually you're wanting to do it via Zoom. I would be much more likely to grant that if you were current on what you owe on pretrial release. That means your pretrial release officer fees and your court-appointed attorney fees. If you were current on those, paid up, then I'm sure that we could do the paperwork and you could appear by Zoom and we could do that plea via Zoom. But if you're delinquent $400, then I'm going to want you to come back.
Your Honor, could we set it for Zoom contingent upon him being current on or before the date of the plea hearing? And if there is any shortfall, then
Let's do this. Just when you find out exactly what he owes. He's got you haven't paid that yet, have you? He's got $50 money order, so just subtract that. You just anticipate doing the paperwork via mail or email?
yes.
We'll also need to get a fingerprint at some point. So he'll either have to come back to do that, or you'll have to stay. You'll have to coordinate with someone in the other in Louisiana to take the fingerprint and send it back.
Have it take the Harris shift, help us out.
You could, won't be us, but it'll be the DA's office. It'll be up to them. Or you can get it today before you left. Just on a fingerprint document. An addendum to the judgment. Standing alone is just a fingerprint, means nothing. All right, Mr. Dixon. So what you owe is, not counting the 50. I've already subtracted your $50. It's $390. That's what you owe for your bond supervision fees and your attorney fees. If $390, he's going to incur another 50 next month, right? For July. Would we be coming back in July? Would we be pleading this out in July?
July 7th.
July 7th? Okay, so if $390 was paid before July 7th, then we could appear via Zoom. Assuming you'll have all your paperwork done, signed, all those things. So this is what we'll do, Mr. Dixon. I'll set you for plea on July 7th. That'll be at 9 a.m. unless if you've paid your $400 that you owe to the probation department for the bond supervision and towards your attorney fees that you're going to incur in this case. Then, if you get all that paid before the 7th, then I'll allow you to appear via Zoom to do your plea so that you don't have to drive back down.
And that's 390.
Yeah, 390. I would just 390. I'd call it $400.
390. Oh,
390, and then you enter your plea before the court. Now there's going to be, I'm sure that Mr. Adams is going to bill more than $350 for attorney fees. So there's going to be more that you owe, but you won't have to pay it on July 7th. You'll be able to pay it, send it in the mail, pay it off. You're going to have court costs. You may have reimbursement fee. You're going to have reimbursement fees, court costs. You're going to have probably restitution, I'm assuming. I don't know all the plea agreements. So Mr. Adams and Mr. Woodwine will have to work that out, and he'll tell you that. But doesn't mean that you're going to be walking away with nothing else to owe. Is Chester here?
Some wants or something.
I haven't seen any waiver of rates. It's in Chester on Sperling or Ibarra Avenue. Those are what you clients. How did Mr. Law do? I need to withdraw it. Go back to jail. And then get something in writing. Collect all of our stuff. Get something in writing. Jail saying they never received it. Get something for that. So that we can say forward. Mr. Ibarra and Mr. Sperling, just stay where you are. We're waiting to hear from your attorney. Have y'all spoken with your attorney, Ms. Chester? No? Okay. She may be detained in another court, but we're checking on her. So you're free to, if you want to step outside, take a break or whatever, you're free to do that. Just don't go anywhere until I tell you you're free to go, okay? But we'll let you know when we hear from her, and then we'll call your cases and get you out here. Have you checked with them? Free trial release, it says here. Mr. Ibarra, come on up. Oh, I'm sorry, you Mr. Sperling? Oh, I'm sorry, I need both of you. All right, so hey, why don't you guys, while we're waiting, go ahead and check in with pretrial release. There's conditions of pretrial release paperwork that they're going to go over with you. So you can fill that out while we're waiting, and it'll save you some time once we call your case. Back on this.
check.
Eric Sperling.
Okay, Casey, can you hear me? Okay, we don't hear you. So what have I done?
Can you hear me now?
Okay.
Okay, perfect.
Uh-oh, now we're hearing them in there. Hang on just a second, Casey.
Okay.
Okay, just a second. I gotta put you in a breakout room.
Okay.
All right, good morning, Ms. Chester.
Good morning, Judge.
Great. All right, Ms. Chester, can you hear me okay?
Yes, can you hear me?
Okay, for some reason, I don't have you, my speakers turned up. It shows that you're unmuted. Sure. I'm gonna mute you and then I'll let you, now unmute yourself and let's see.
Can you hear me now?
Yes, I can hear you now.
Okay,
Excellent.
perfect.
All right, good. All right, Mr. Sperling, if you'll come up, this is cause number CR 22157, State versus Eric Glenn Sperling. We are set for arraignment today. Ms. Chester, have you had an opportunity to go over the indictment with your client?
I have, Your Honor. He has informed me that his name is spelled correctly as it is put in the indictment. He understands the charge and the punishment range included in the indictment. At this time, we would enter a plea of not guilty and ask for a pretrial setting.
All right, court will enter Mr. Sperling's plea of not guilty into the record. Court will set pretrial in this matter. Ms. Chester, I've got July 19th or 21st.
The 21st would probably work better. Is it at 9?
Yes, ma'am. It'd be pretrial at 9 on July 21st.
Okay, perfect. That would work.
And if you're still on travel restrictions at that time, just let Ms. Abraham know. We'll make sure you zoom in for pretrial.
Okay, perfect.
All right, Mr. Sperling, once you sign and get this notice, the yellow copy of this notice, your next date will be July 21st at 9 a.m. You've got your conditions of pretrial release. You know what's required of you. After you get those, you're free to go.
All right.
All right, come on up. You can sign with Deputy Phyllis. Mr. Ibarra. All right, this is. Deputy, please, will you check that laptop out there, make sure it's muted? There's a.
It is, Your Honor. How soon is muted up here? Is that better?
Yeah. We'll try that. Mr. Waddell, Mr. Waddell, Mr. Waddell, Mr. Waddell. All right, this is cause number CR 22-161, State versus Joshua Andrew Ibarra. We are set for arraignment today. Ms. Chester, have you had an opportunity to go over the indictment with your client, Mr. Ibarra?
I have, Your Honor. He has informed me that his name is spelled correctly. He understands the charge and the potential punishment range. And at this time, we'd enter a plea of not guilty and ask for a pretrial setting.
All right, the court will enter Mr. Ibarra's plea of not guilty into the record. The court will set the next hearing for pretrial July 21st. That'll be at 9 a.m. Mr. Ibarra, you're going to sign with Deputy Phillips here. We're going to give you a yellow copy, or Deputy Police rather. We'll give you the yellow copy. You have your conditions of pretrial release. You understand that you have to report, you have to pay towards your bond supervision, you have to pay towards your court-appointed attorney. You understand? I'll make sure you're in compliance with all those conditions. Sign right there, and once you get the yellow copy, you're free to go. All right, Ms. Chester, I believe that's all you have today.
It is all I have today, Judge, and I'll make sure to get on Zoom. I have the code now, so I'll get on earlier on Thursday.
Okay, you don't have anything this afternoon, do you?
No, I do not. I do not believe.
All right, well, enjoy your afternoon. Good to see you.
Thank you. Good to see you, Judge.
So, what about it? Oh, yeah, he's done. Yes, you want the update on Bill Stevens, all of Bill Stevens. All right, court has called the name Tommy MacArthur Jones for docket today. Mr. Jones was not present at 9 a.m. nor is he present at this time. 11:20 a.m. The court has had his name called loudly and distinctly 3 times in the courthouse. There's been no response. Court hereby issues an alias capias for the arrest of Tommy MacArthur Jones. I believe that concludes the morning docket. Court's going to stand in recess until the afternoon docket at 1:30.